You're saying a 36-year-old, your son, wanted an item, so you stole it for him?
I bagged it.
Stole.
Yes.
Did you pay for it?
No.
Then when you bag it and leave with it and you didn't pay for it, that's called stealing.
Yes.
So why do you continue to steal?
I'm no longer going to stores.
No, that's not my question. My question is, why do you continue to steal?
She blamed it on her 36-year-old son wanting an item, which clearly did not sit well with the court. Watch what happens next.
All right, the court is calling 2022 CR 4821 and 2022 CR 4822, State of Texas versus Alma Barrera. Could I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
James Hunt.
And are you Ms. Barrera?
Yes.
Ms. Barrera, in each of the cause numbers, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, in each of the cause numbers, I'm showing you the discovery acknowledgement. Have you received all the discovery in each of these cause numbers, and did you review that discovery with your client?
Yes, Your Honor.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. Ms. Barrera, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, I did.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each of the cause numbers?
Yes, Judge.
Ms. Barrera, in each of the cause numbers, I'm showing you documents entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places?
Yes, I did, Your Honor.
Did you understand in 2022 CR 4821, you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. The range of punishment is anywhere from 180 days in the state jail facility up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And cause number 2022 CR 4822, you're charged with the offense of hindering apprehension or obstruction of an investigation as a third-degree felony. The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses in either of these cause numbers?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane in each of these cause numbers?
Yes, Your Honor.
Ms. Barrera, in each of the cause numbers, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived her right to jury trial in each cause number. In each cause number, I'm showing you the plea bargain agreement. Did you review that agreement with your attorney? Did you understand it?
Yes, ma'am.
The plea bargain agreement in each of these in 2022 CR 4821 is punishment to be assessed at 2 years in the state jail facility. There's a $1,500 fine to be probated. State recommends community supervision. This will run concurrent with 2022 CR 4822. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense and state, is that the plea bargain agreement?
Yes, Judge.
Yes, Your Honor.
In cause number 2022 CR 4822, according to the plea bargain agreement, punishment is to be assessed at 8 years in the prison. There's a $1,500 fine probated. State recommends community supervision. It will run concurrent with 2022 CR 4821. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense and state, is that the plea bargain agreement?
Yes, Judge.
Yes, Your Honor.
In each of the cause numbers, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, in each of the cause number, have there been any such motions?
No.
In each of the cause numbers, I'm showing you outside the agreement. In cause number 2022 CR 4821, the state is asking that your community supervision be for a term of 5 years. There'd be a TAP evaluation, 100 hours of community service restitution, no contact with any Walmart, CATS 1 and 2. In 2022 CR 4822, the state is requesting that community supervision be for a term of 5 years. There'll be a TAP evaluation and 100 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in cause number 2022 CR 4821, how do you plead? Guilty, not guilty, or no contest?
Guilty. No. No contest.
And in cause number 2022 CR 4822, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State Office States Exhibit 1 and all attachments in both cause numbers.
No objections.
And each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
And each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments to review the same. After reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We believe that the plea bargain is appropriate in these cases and ask that the court follow.
All right, Ms. Barrera, is there anything you wish to say?
No.
Why do you continue to steal?
It was a confusion that
No, it wasn't a confusion. You stole, and this is the third time you stolen. So my question is, why do you keep continuing to steal?
I had stopped, and then I don't know, my son he wanted the item and I just bagged it.
So how old is your son?
36.
I'm sorry, what?
He's 36.
So you're saying a 36-year-old, your son wanted an item, so you stole it for him?
I bagged it.
Stole. Did you pay for it?
No.
Then when you bag it and leave with it and you didn't pay for it, that's called stealing.
Yes.
So why do you continue to steal?
I'm no longer going to stores.
No, that's not my question. My question is, why do you continue to steal? Everybody else who goes to the store, if there's something there that they can't afford, guess what? They don't get it because they can't afford it. So why are you stealing items? That's what I don't understand.
Yeah.
Is that your
I wasn't
occupation?
thinking. I just
No,
bagged
you
it.
were thinking, because first you told me that your son wanted it, so you got it and you put it in a bag, you stole it.
Yes,
And now you're saying you're not thinking. I don't understand, why do you steal? Because I don't think there's anything to do to help you, because you are just stealing because that's your occupation.
yes, but I don't steal no more.
Yeah.
I
Do you
will
have a
go to the
job?
Store.
Do you have a job?
No,
How are you supporting yourself?
I had a injury. I had an injury and I received a
What kind of injury?
I had a accident and cut all the tendons on my hand, and I can't work, so. My hand was paralyzed, but they
So are
were
you
able to
saying-
fix it because of the
So
accident.
where do you get your money from to support yourself?
I get the disability.
All right, and cause number 2022 CR 4821, this is what the court is going to do. The court is finding you guilty, sentencing you to 2 years in the state jail facility, suspended and probated for 5 years. There's $1,500 fine, probated. This is run concurrent with 2022 CR 4822, 100 hours of community service restitution. CATS 1 and 2. I don't know if CATS 1 and 2 is going to help you. Don't steal. I mean, that's what CATS 1 and 2 teaches you, not to steal, but you steal anyway.
No.
No, you do. And it needs to stop.
Yes. I don't go to the stores. I don't want to steal.
There should be no contact with Walmart. I'm going to want field visits 3 times per month. If you're drug tested today, what are the results going to be?
Clean.
I'm going to want a drug test today. If she is not clean, I want a motion to revoke file. So there's going to be a drug test today. You understand? So you still going to say you're going to be clean?
Yes, ma'am.
All right. I want a drug test today by 3 p.m. There should be regular reporting, in person or by Zoom. Proof of SSI within 30 days, or employment, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Do you have any minor children in your household?
No.
There should be no unsupervised contact with minors. So if you have grandchildren, they need to be supervised by another adult other than yourself. You understand?
I understand.
And there is to be regular UAs. And cause number 2022 CR 4822. Court is following your agreement, sentence you to 8 years in prison, suspended and probated for 5 years, $1,500 fine, probated. Proof of SSI within 30 days, or employment within 30 days. No employment as a home health care provider with minors. No unsupervised contact with minors. Concurrent with 2022 CR 4821. $100 hours of community service restitution. UA today by 3 p.m. Regular UAs. I'm going to want the field visits. Regular reporting in person or by Zoom. Probation, is there anything else that she needs?
No, Your Honor.
Is there anything else you need from me in order to be successful in these probations?
No.
All right, I'm going to show you in each of these cause numbers what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because these are felony convictions in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. Here's the thing. If you want something, you have to work for it and actually get a job. When you steal, guess what? That price is passed along to the consumers, which is me and everybody else who works and pays for what they want. You understand?
Yes.
All right, who are the parties on Victor Pettis?
Yeah.
Court is calling 2021 CR 4512, State of Texas versus Demille Thomas. Can I have parties approach and announce for the record? For the state,
Ryan Burmer for the state of Texas.
for the defense,
Todd Lessard for Mr. Thomas.
and are you Mr. Thomas?
Yes, ma'am.
All right, Mr. Thomas, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Demille Deshawn Thomas who was placed on deferred adjudication in 2021 CR
Yes, Your Honor.
4512 for the offense of aggravated assault with a deadly weapon on August 23rd, 2021 for a period of 5 years? Is that you?
Yes, Your Honor.
State?
Yes, Judge. Violated condition number 2, that on or about the 5th day of May, 2022, in Bexar County, Texas, the defendant Demille Deshawn Thomas did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor. And then violated condition number 5, that in Bexar County, Texas, the defendant Demille Deshawn Thomas did then and there fail to report to the supervision officer as directed for the months of March and April 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True, Your Honor. That we waive the remaining conditions.
Any objections to the state's waivers?
None, Your Honor.
Did you understand by pleading true to violations 2 and 5, the court could find it true, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 2 and 5?
Yes, Your Honor.
Court will find 2 and 5 true. Is there an agreement?
We do have an agreement, Judge. We have an agreed recommendation to make to the court that you deny the motion to adjudicate and that we alter and amend to add SATA with aftercare to Mr. Thomas's deferred adjudication.
Is that the agreement?
That is the agreement, Your Honor.
All right. The court will deny the motion, alter and amend conditions to include SATA with aftercare. And also probation. Can you see if felony drug court would consider accepting him? So we'll do a referral with felony drug court. Let's try that first. And then if they say no, then he's to do SATA and aftercare, and he's to remain in custody until transfer.
Yes, Your Honor.
All right. Is there anything else?
Nothing from the state, Your Honor.
Nothing
Mr.
from the defense, Your Honor.
Thank you. Mr. Thomas, is there anything else you need from the court in order to be successful?
No, ma'am. Thank you.
All right. Good luck to you. You're going to have to do better. You understand?
Thank you, ma'am. Yes, ma'am. Yes,
You're welcome.
This case follows Alma Barrera, who stood before Judge Boyd facing theft and obstruction charges, and let's just say her explanation did not go as planned. When asked why she kept stealing, she blamed it on her 36-year-old son wanting an item, which clearly did not sit well with the court. Judge Boyd quickly cut through the excuses, pointing out this was not her first offense and questioning her logic with visible frustration. The courtroom had a tense but almost unbelievable moment as the defendant struggled to justify her actions. In the end, Judge Boyd accepted the plea deal, but made it clear this behavior had to stop, sentencing her to probation, strict supervision, and a firm warning: no more excuses.